This is part 2 of our series looking at the criminal justice reforms in New South Wales. Today's episode is about sentencing laws, and we're joined again by Nick Ashby, criminal lawyer.
Welcome to Law for Community Workers on the Go, a series of podcasts designed specifically for community workers, health workers, and anyone else who works to support people in their community. This series is brought to you by the Community Legal Education team here at Legal Aid New South Wales, and our aim is to help you help your clients. So tune in whenever you can, in the car, on the train, at the gym, cooking dinner, basically wherever you already listen to podcasts. So we hope you enjoyed today's episode and that you learned something new and interesting.
A lot of people will be familiar with some sentencing terms like home detention, good behaviour or good behaviour bonds, community service and suspended sentences. But there have been some big changes, so keep listening to learn about what's happened to these terms. Before we start, we would like to acknowledge the traditional custodians of the land that we are broadcasting from today, the Gadigal people of the Eora Nation, and pay our respects to elders, past and present. I asked Nick first to explain why New South Wales is changing the laws on sentencing.
First point being that the jails are bursting at the seams, and these reforms are meant to make community-based sentencing options, and that doesn't mean just community orders, but also jail sentences being served in the community, more available to the courts, to hopefully mean a greater number of offenders can serve their sentences positively and constructively in the community while subject to supervision and other conditions.
And there's research about that being more effective.
That's right.
Short.
So the strategy is around reducing reoffending through having more people remain in the community while serving whatever their sentence be, and also to introduce, a more intensive supervision regime to complement that, as that's also been shown to have a significant impact on a person's likelihood of reoffending.
Just to clarify, there are some types of prison sentences which are served in the community, which means that the person doesn't actually go to jail, but they do have strict supervision and conditions. Community corrections officers are the ones responsible for this supervision. There are a lot of new terms and, as a result, acronyms for us all to become familiar with. Let's start with hearing from Nick about which sentences are being abolished and replaced by the new sentencing option of intensive correction orders, or ICOs.
So first of all, home detention as a standalone order is being abolished. That will be brought within the regime of a new intensive correction order as a sentencing condition.
So ICO, some people say, or intensive correction order.
That's right, an ICO.
Community service is another sentence you might be familiar with, and that one's also changing. The new sentence we'll hear about now is a community correction order. So
people will no longer receive community service orders, but depending on the view of the sentencing court, the magistrate or the judge, they would be receiving either a new intensive correction order or a new order called a community correction order with a community service condition.
The next term we are saying goodbye to is the good behaviour bond. This is also replaced by community correction orders.
Thirdly, the old good behaviour bond, Section 9 of the Sentencing Act, that is being abolished. Those good behaviour bonds will convert to the new community correction order, and that will happen automatically on the 24th of September, but will become no more onerous. So clients won't necessarily even know this has occurred. We don't know how this is going to be communicated to them, but essentially it will be an automatic consequence of the commencement of the legislation.
Another one that's changing is Section 10s. That might be a term that people are familiar with. So Section 10s can be given by a court either with a promise to be of good behaviour or without. So if it's a Section 10 with a promise to be of good behaviour, that is now called a conditional release order. But the Section 10s with no conditions, there's no change to those.
So 10.1a is being retained, so there can be a non conviction with no further penalty, but 10.1b, non-conviction with a good behaviour bond, will become the new conditional release order, and 10a, so a court that convicts an offender may dispose of the proceedings without imposing any other penalty. That is also being retained, as are fines, as are what we lawyers call the Griffiths remand, the Section 11 remand, where a person can be placed subject to bail with conditions to undertake rehabilitation before the court makes the ultimate sentencing decision. So a lot of sentencing options are being retained, but anything which is essentially community-based is going to be subject to these reforms.
So let's just summarise what's not changing with sentencing in New South Wales. So Section 10's without conditions, fines, so there's no changes to fines, and also what lawyers call a Griffiths remand. So, for example, that's when the court allows someone to go out into the community, often to a drug and alcohol rehab, for example, and then they come back to court and are sentenced at a later date. So Griffiths remand, no changes there.
Now, suspended sentences are being abolished, and this is quite significant. Suspended sentences under Section 12 of the Sentencing Act, anyone who is subject to a suspended sentence will continue to be subject to a suspended sentence after the 24th of September. Those are orders that will not be converted to anything else, but if breached and a person is returned to the sentencing court on breach of a suspended sentence, then the resentencing exercise will be subject to the new regime. So the court will either be imposing full-time jail, as they historically always would have done, or the court could impose one of the new intensive correction orders with the other options that apply to that order.
Now let's hear from Nick about what's happening with the old suspended sentences.
So an intensive correction order is still, as it always has been, is still a jail sentence. So the court would have to consider that a jail sentence is appropriate. For a single offence, an intensive correction order cannot be imposed for longer than 2 years. Under the new regime, the court will be able to accumulate these orders up to 3 years for multiple offences. So that's an increase in the length of the order that the court could have in mind. But essentially, yes, that's a jail sentence in the community. The court wouldn't be making these orders unless they have considered that a person has crossed the threshold to merit a jail sentence.
Let's take a step back and have a closer look at the intensive correction order, which would be applied in more serious matters.
On breach, if a suspended sentence is breached, of course the court can set essentially a period of time to be served in jail, which could be significantly less than the actual length of the suspended sentence order. Whereas if an intensive correction order is breached under the new regime, then that is administered by the State Parole Authority, and as practitioners will be aware, but perhaps not community workers, when setting an intensive correction order length, so say the order is 12 months, there is no non-parole period set. So upon breach, a person is liable, and again it's a bit more complicated than this, but is liable to go to jail for the full term of the order.
There are also changes to breaches in relation to the new intensive correction orders.
So what we would used to ask for a good behaviour bond without a conviction under Section 10.1b of the Sentencing Act, you would now be asking for a conditional release order without conviction. The court can impose a conditional release order with conviction, and in either case can set these conditions, could set a condition of, for example, supervision or alcohol and drugs abstention, or to engage in a programme.
Let's now review conditional release orders and what those conditions might look like.
So a community corrections order is the higher version, the more serious version of a community order. So it's an alternative to jail, but it would be imposed where the custody threshold has not necessarily been crossed. And to that, the magistrate or judge could add community service of up to 500 hours.
That's quite a lot.
That's a lot of hours. And also supervision, and also could impose a requirement to go and undertake appropriate programs and treatment, or abstain from alcohol or drugs. So that's a community corrections order.
Coming back to the community correction orders, let's have a look at the conditions that can be imposed.
And then the next rung up the ladder, as it were, if the court is not going to impose full-time jail, is the new intensive correction order. There are certain improvements from a defence point of view. because the previous requirement for an ICO to contain a mandatory 32 hours per month of community service, that requirement has now been abolished, or will be abolished on the 24th of September.
Yep.
And which means that these orders are going to be available for many more people than previously couldn't receive an ICO, and would ultimately be sent to full-time jail because the court had no other option. So, for example, people who live in country areas where community service is not freely available, or even people who are, for physical or mental health issues, perhaps not suitable to undertake community service, they can now be brought within that sentencing regime. So we think it's going to open up a lot more opportunity for these sorts of offenders to receive ICOs rather than full-time jail.
Now moving up the hierarchy of penalties, we'll now come back and look at intensive correction orders.
As I say, there were just resource limitations in some regional areas, which limit the capacity for community corrections to provide community service placements. So if it's no longer a mandatory requirement for a person to have a community service requirement as a condition of an ICO, that means that they could be subject to an ICO, perhaps with other conditions. They will have to be subject to supervision, but they could also be subject to home detention or electronic monitoring, or again, other programs, alcohol and drugs abstention, these sorts of...
And hopefully some of the new corrections officers will be available in those regional areas.
We hope so. We hope so. As I say, it's I think a bit of a wait and see.
Yeah. It's important that we don't just focus on metropolitan areas. So let's have a look at how these changes may impact regional areas.
That's right. So community corrections officers will be responsible for tailoring supervision to suit a person's particular circumstances. Again, there's been a lot of research in this area. It's going to be we understand, a significantly improved regime. It's going to include a lot more focus on cognitive behavioural therapy and risk management. And there's also going to be power for community corrections officers who are supervising a person subject to one of these orders to have more discretion over whether they refer a person for breach, either back to the court in the case of a CCO or CRO, or to the state parole authority if a person is subject to an ICO. So
it's also good to point out that this supervision we're talking about here is only done by community correction officers, not by community workers.
Officers also have some additional powers in terms of suspending some conditions of these orders.
So the orders can change?
The orders can, there's some limited power to do that. And of course, upon breach, the courts would have the power to impose more onerous conditions, as well as resentence.
So could that be if the victims feel unsafe or there's some problems going on? Can the onerous conditions be put on?
Difficult to sort of to come up with a sort of one-size-fits-all answer to that. Yeah. But look, in a domestic violence context, there's obviously there are some changes around ICOs that we should probably touch upon. Yeah. You know, one would have said it's probably more in the context of not going to the appointments for supervision, perhaps missing some community service work, any new offences. So are likely, and certainly in the context of an ICO, it would be a mandatory reporting to the state parole authority for breach. But again, coupled with that, the officer can make recommendations not to take any further action. So if the new offence, for example, was perhaps someone with an entrenched drug dependency is found in possession of a small amount of whatever their narcotic of choice is, it may well be that whilst that offence would trigger a mandatory referral to the state parole authority with a recommendation that no further action be taken, hopefully that the authority would exercise that discretion. And coupled with that, there is I understand, a significant change to the requirement to report where a person has tested positive for drug while subject to an ICO. That is not, as I understand it, will not be from the 24th of September, a mandatory reporting trigger.
What about breaches of parole in the new regime? What's changed?
But as I say, it's a more flexible regime. So if the courts are receiving people before them for breach of a CCO or CRO, then the court could. That's right. Community corrections order, conditional release order. Then rather than breach, revoke and resentence, it could be that the court imposes more onerous conditions to reflect the breach, so that a person subject to the order can continue to be subject to the order, but may have to do some, for example, some additional community service or a drug
have to go to rehab.
Or rehab. Yeah. As I say, these are orders which are designed to have more flexibility, with a focus on keeping people in the community whilst serving out the punishment and rehabilitation which is around which the sentence is designed.
So just to recap, which types of offences are affected by the reforms? And our earlier podcast about the Early Appropriate Guilty Plea reforms was just in relation to serious offences, but these sentencing changes in New South Wales apply to all. That's right. Offences.
So the sentencing reforms have application in the local court, to summary proceedings, and also in the district court.
Let's have a look at the changes made in relation to domestic violence offenders.
Well, that's right. The main change is that the sentencing legislation will now effectively contain a statutory presumption that a person convicted of a domestic violence offence should receive a full-time jail sentence. Now, that does not discount the possibility, and in fact the law provides that a person could receive, as an alternative to that, a supervisory order. So a supervisory order would be any of the three orders we've been talking about. So an intensive correction order, a community correction order, or a conditional release order, provided it is subject to and it contains a supervision requirement. And in fact, no sentencing options are ruled out in the context of domestic violence offenders. It just creates a presumption, and I would have thought an expectation that the magistrate should have due consideration of full-time jail, and then obviously the defence lawyer or the offender will have to address that statutory presumption as in the sentencing advocacy. The other aspect of domestic violence that we should all be aware of is the limitations on intensive correction orders, and unless the court can be satisfied that the victim can be protected, should not be imposing an intensive correction order, for example, for someone to go and live back at the address where both parties live. Now, in reality, that's probably not much of a significant change, because certainly in my experience, where offenders are assessed for intensive correction orders and they have to have a written assessment by a community corrections officer in most circumstances, certainly it's a statutory requirement for home detention. One of the first issues that the report writer would address would be the accommodation, and generally speaking, the courts would be reluctant to send an offender back to an address where it would be placing the victim at risk. So whilst the law has been changed, in all practical reality it may not be that significant or as significant to change as one would assume at first glance of the change to the legislation.
So community workers might have clients who come to them and are really confused about these changes. They might currently be on a suspended sentence or have a community service order and might be really confused about what's going to happen when these reforms start. What should those people do?
That's right, depending on where they live. There are clinics, usually walk-in clinics, depending on the office, whether it be Central Sydney or a Sydney Metropolitan Office or a regional office. And you know, the lawyers there should be able to advise on the implications for any sentences that are going to be automatically converted. But I stress, whilst they may have a different name, whilst it may be called a community corrections order instead of a good behaviour bond, the legislation will not make the order any more onerous. But I suppose there may be consequences on breach and resentencing because the new regime will apply. LawAccess is another.
1300 888
They may not necessarily have the expertise and to give the precise sort of implications of the changes. But I don't mean that they can certainly refer people back to legal aid. Yeah. And of course, there are duty lawyer services at the local courts for people appearing on breaches.
And on that, there's also help available at courts for victims.
That's right,
particularly
of course.
Victims of domestic violence. Spencer's the Women's Domestic Violence Court Advocacy Service.
That's right.
So if victims are concerned about the changes or how it will affect them, then they can contact the...
That's right. Most local courts have a domestic violence list, and my understanding is that most of those lists are attended by someone from the Women's Domestic Violence Court Advocacy Service to assist victims at court.
Yep. And we had another podcast about the ADVOs as well, because they changed a few years ago, other reforms. So thank you so much, Nick, for your time and expertise today. And we will see you maybe next time as these laws keep changing. Okay, thanks, Nick.
Law for Community Workers on the Go is brought to you by Legal Aid New South Wales. Our aim is to help community workers, health workers, and anyone else who works to support people in their community know about the laws that affect their clients and the services that are out there that can best help. Now, there's really only one way we can make sure that information is relevant and helpful to your work, and that's with your help. So if you have any feedback for us, or maybe your clients keep asking you the same thing and you just want to know more about that topic, then please get in touch with us. The email address is cle@legalaid.newsouthwales.gov.au. Make sure you follow our podcast channel on either iTunes or the Podbean app. And if you haven't already, be sure to subscribe to our Law for Community Worker alerts to find out what webinars and podcasts are coming up. You can subscribe to our alerts by going to the Legal Aid New South Wales website, hitting the tab News and Media, and then just follow the links. Until next time, thanks again from the CLE branch here at Legal Aid New South Wales.